I'm glad you asked that, Chef. Nobody's really asking. On the ground, as a person who's...
The Fifth Amendment of the Constitution protects him from speaking. My name is David Bruno, and I'm with the former Morris County Prosecutor, Bob Bianchi. We're partners at the Bianchi Law Group located in Morris County, New Jersey. We lead a team of former prosecutors who aggressively fight the government when our clients are charged with crimes. Today, we'll be talking about a recent New Jersey Supreme Court case that interpreted whether or not defendants could be charged with contempt for violating pretrial release conditions. The Criminal Justice Reform Act took effect on January 1st of 2017 and completely changed our bail system in the state of New Jersey. We went from a system which required cash, bond, and/or property, and shifted to a combination of non-monetary conditions based on risk assessments, such as conditions that require reporting to the newly created pretrial division, maintaining employment, complying with a curfew, no contact orders, GPS ankle monitoring, and our home detention, to name a few. On July 20th of 2020, the New Jersey Supreme Court clarified a very important issue of pretrial release, which is, what is the penalty if a defendant violates a pretrial release condition? Prosecutors had been filing new contempt charges against defendants who violated pretrial release conditions. In the state of New Jersey versus McCrae, 2 defendants violated their pretrial release conditions. Both defendants were charged with contempt and both appealed. The New Jersey Supreme Court, in an opinion written by Chief Justice Rabner, held the history of the Criminal Justice Reform Act indicates that the legislator did not intend to authorize criminal contempt charges for violations of release conditions. The court distinguished these other pretrial release conditions from the no contact condition. A violation of the no contact condition may still be used as a basis for separate contempt charges. This is an important decision interpreting the Criminal Justice Reform Act. Prosecutors must now move for detention instead of new contempt charges. If the prosecutor moves to detain based on these violations, a defendant still is entitled to a detention hearing before a Superior Court judge. Bob, as the former head county prosecutor of Morris, what do you think about this decision and generally how our bail system has changed since the Reform Act?
Yeah, so this is an interesting decision, and so our audience understands. Typically speaking, when you violate a judge's order, Dave was referring to it as a contempt. That's actually a criminal charge, a 4th-degree offense carrying up to 18 months in state prison. So what this decision essentially is saying is that not all of the bail conditions should result in a contempt charge. Of course, a no contact order is, but not necessarily all of them. So that just puts the prosecutor in a difficult position, because what their only remedy left is now is to say to the judge, we want to have another detention hearing, and because he violated or she violated part of your order, we believe they should go back into jail and pending trial. And the importance, Dave, to your point, was that when we had a money-only or monetary bail system, we used to have people in the county jail that couldn't make $200, $300 bails that would wait there for a year or 2 years, where people with much more serious offenses were able to make the bail and get out. And the real importance to that, not only for the client, who doesn't want to be in jail, of course, is access by the defense lawyers to those clients, because it's very difficult to represent somebody in jail. Many studies have been done that your ability to represent somebody properly diminishes greatly when you have to have certain visiting hours. You can't bring all the materials in. You can't have that healthy and robust dialogue that you want with your client and access to your client when you need to ask them questions. So the bail reform was very, very significant, and it's based on this risk factor, and many people have been released, which helps us assist them in their defense. So the other really important thing about bail reform that occurred, as Dave indicated, over 3 years ago, is that now if there's a detention hearing or the prosecution is moving for detention, we're entitled to discovery, or that is information like police reports, investigative reports, things of that nature, so that we can prepare for that detention hearing. The reason that's important is it allows us to better assess a defendant's case in the beginning Also, investigatively, which I believe defense lawyers should be robustly investigating cases to make sure that maybe videos or electronic data that's stored somewhere is not destroyed in anticipation of being able to use it in your defense. So it gives defense lawyers a really huge advantage by getting those reports sooner than later. So Dave, those reforms have been excellent, and now prosecutors will, under this ruling, not be able to file an additional criminal charge. They can only go to the court and say, Judge, they violated this condition, and we believe based upon that, you should put them in jail. Of course, if you get out of jail, keep in mind, that's a huge thing for you, not only for your personal freedom, but a huge thing in assisting your defense lawyers in the case.
Yeah, all great points, Bob. I mean, it's important to stay up on this law. It's an evolving procedure in law, these pretrial hearings. We are up on them. We practice in all 21 counties. And I think the biggest takeaway, like you said, is the fact that we get discovery much more quicker than before if the state files for detention. That's another Supreme Court case, State versus Robinson, which interpreted the discovery rules in the pretrial hearings. So we're on it. We're out there. We're going to continue with these videos, keeping everybody informed. And at the Bianchi Law Group, we are a team of former prosecutors. We're always ready to aggressively defend you if the government has brought charges against you. If you or a family member has been arrested, call our office 24/7 at 862-210-8570 to talk to our team and schedule a consultation. We practice in all 21 counties throughout the state of New Jersey. It is our team's mission to assist you with the courage, compassion, and commitment. Thank you.